This video has been designed with judges, advocates and experts in mind to show how concurrent evidence works in a civil trial. To help with this, we've adapted some parts from a resumption case where the applicant claimed $29 million in compensation. Before we take you to that case, let's remind you of how expert evidence would be taken in a conventional trial. Most of you will be familiar with the conventional adversarial process, where each party calls their own experts who are examined in chief, cross-examined and re-examined separately. This means that in the plaintiff's case, the necessary experts will be called and their evidence taken, and at a later time in the trial, the defendant's experts will be called. In many cases, their evidence will be separated by days. It can be weeks, and they will never have the opportunity to respond directly to each other's material.
Mr. Reynolds, concentrate. Concentrate on my question. It was a fairly simple question. You know that these proceedings...
Experience has shown that many experts find the adversarial process to be threatening, and they complain that they do not have an opportunity to adequately express their position. This may occur when they are being examined in chief or when being cross-examined, because they can only respond to the question they have been asked.
Now let's go back to my question. A RAMA is a heritage listed item, isn't it?
Yes.
Now that's not that hard, is it? Let's answer the questions as I ask them, and we'll get through this a lot faster, sir.
Because they don't see it as a search for the truth, many qualified people have said that they will not give evidence in court. Another complaint is that the adversarial process can be unsatisfactory, because although the expert knows the question that should be asked, their advocate may not.
You included an allowance for profit and risk, didn't you?
Yes.
That was incorrect, wasn't it?
No. That's not right.
Another problem is that although the expert advising the advocate knows the answer is wrong, again, the advocate may not.
Shouldn't profit and risk have been ignored because the valuation exercise that you were undertaking was hypothetical?
Not at all.
Experience also shows that the conventional process can be lengthy, and a great deal of time can be taken in debating matters that are of little or any significance in the resolution of the real problem. Now let me explain to you how concurrent evidence works. The first step is for the experts to prepare and exchange their written reports. This is a step sometimes taken in conventional litigation. With concurrent evidence, the court will always require the experts to meet before the trial and identify the areas in which they have a common view and the areas where they disagree. They are then required to put on paper a statement of their position. At the appropriate time in the trial, the joint statement will be tendered and the experts called to give evidence. I have presided over cases where as many as 8 experts have been called to give evidence at the same time. Imagine how much conventional courtroom time that can save. Once sworn, counsel for the parties are asked by the judge, working from the joint statement, to settle the topics which the court will have to consider in order to resolve the differences between the experts. This becomes the agenda for what I refer to as a structured discussion. As I mentioned earlier, we are going to illustrate the process from a case which involved valuing a major golf course development in order to determine the compensation payable by the electricity authority which constructed a transmission line through the property. There were 2 parties, the owner and the authority, and each of them had retained 2 valuers. The valuers each had different views as to the appropriate compensation. What you will see are excerpts which we have taken from the actual transcript to illustrate the process of concurrent evidence. Now, I think perhaps you all understand the process that we're going to go through, but let me just explain it to you again. I have here, as you know, the document that you've prepared which shows me where you agree on things and where you disagree. That's our starting point. I'm going to invite counsel in a moment to tell me of the issues which they believe need resolution And then I'm going to go from the list of issues that we agree to ask each of you to contribute to a discussion about those issues. You'll have the chance to ask each other questions and a chance to tell me of your position in relation to those matters. Now, you should also understand that I've had the chance of reading your written reports, although I don't profess at this stage to fully understand them. It's important that we all agree that the process is not an argument. Rather, it's a discussion designed to inform me of your position in relation to each of the issues. Mr. Coles?
If Your Honour, please. It seemed to us that we might explore firstly the question of methodology, or what I might describe as valuation rationale. In particular, we would, from our part, see benefit in focusing on the question of the respective valuers' approaches in not adopting what, for whatever reason, a simple before and after approach in relation to the golf course. Then it seemed to us that it might be appropriate to explain or explore the question of sequencing or staging of the hypothetical development. And then lastly, it seemed we would need to look at the question of explore the experts' views on the market for the sale of development property in the Bonneville area.
Yes, Mr. Ayres, do you want to add to that?
No, Your Honour.
Yes, all right, well, you understand where we're going. I think there's a roving microphone there amongst you, is that right?
Yes.
Well, the rules of the process are that you can only talk if you're holding the microphone. You understand? That avoids you talking over the top of each other. Now, you've heard the topics that have been discussed by counsel. The one that interested me at the beginning of the case is why you just don't approach the problem on a straightforward before and after exercise. Now, who'd like to tell me about their perspective on that one?
I would, Your Honour, because one of the problems that I had, and I did initially take the obvious approach, but one of the difficulties when looking at the scale and scope of the project on the before situation is that a significant proportion of the development is for lodges, and primarily on the western side of Cassidy's Road, which is dominated by lodge-style developments and additional retreats. Now, the problem that I had when trying to determine a timescale for those is quite simply that there are no other comparative style of property that I could ascertain within Australia of a similar type of property or a similar style of property.
But I'm not sure I understand why you would need to do that. Why wouldn't you just look at the value of the whole property without a transmission line and ask yourself, what's the value of the property with the transmission line?
Certainly. Well, when you look at the plans for the development and you also look at the land with the line across it, it becomes very difficult because there simply aren't any similar properties available for you to reference against within the country. There's no yardstick.
I understand that, Mr. Blaxland. Perhaps I'll now throw it open to anyone who wants to contribute to the discussion.
Your Honour, I can only comment that my experience is transmission line easements or similar easements, and it's common practice for valuers to assess compensation on a piecemeal basis. The complexity involved in performing what we all know as a complete before and after on the property was something that I felt introduced matters and difficulties that have a tendency to complicate rather than address them, and so I chose to do it on a piecemeal basis.
Yes, very well. Can you tell me, when was the property acquired by the current owner?
My understanding is about 1998.
Beginning of 1998, actually.
When it was acquired, it was affected, was it? But there was a right to compensation?
Yes.
No, there wasn't.
No, it actually acquired more than a right to of compensation.
I see. And at that stage, was there a transmission line on the property?
Yes, there was a line that ran through the property, but there was no easement over that line.
So there was a line, but query how it got there, and with whatever visual impact that line would give. But the sale occurs, as I understand it, with the expectation that if there is compensation over and above, that comes to the purchaser. Now, is my understanding of that correct?
Well, that is my understanding, yes.
That's clearly provided for in the contract, Your Honour, the contract for sale.
Yes, thanks. As you can see, during the opening part of the discussion, it is important for the judge to provide an opportunity for everyone to contribute. It is also important that the judge ensure that the discussion is confined to the topic which has been identified. It is also a useful step to provide an opportunity to summarise issues along the way. I just want to make sure we're all on the same ground at this stage. You say the sale price, if that had occurred at that day, would give you the maximum value of the property unaffected by the transmission line. Is that right?
Yes, Your Honour.
Now, do the rest of you agree with that proposition or not?
Your Honour, if I may, I think the key question here is whether a hypothetical purchaser would pay any more or any less for the property in the before and after situation. So one of the considerations of the hypothetical purchaser in arriving at the highest and best use potentials of the land would be to consider the master plan and whether that master plan actually added value in the before situation or made any difference, or similarly in the after situation would consider the impact of the proposed works on the master plan.